Okay, I think we'll get started. Thanks everyone for joining today's Venable Nonprofit Organizations Group program, The Remote Workforce in Multi-State Tax and Employment Law Compliance, What Your Nonprofit Needs to Know. My name is George Constantine. I'm co-chair of the Nonprofit Organizations Practice Group here at Venable. My role here is to give the briefest of introductions to the program and to my colleagues, and then save time for all the great substantive information that they will have to share. Today's program focuses on a compliance area that is of increasing importance to nonprofits, particularly as so many have instituted remote work options for their employees, and nonprofits starting to employ individuals in many new states. They're also taking on some new compliance burdens and potential legal and tax risks along with that. So our stellar panel of lawyers here will address these issues both from a tax and an employment law perspective. We do have a lot to cover in a brief amount of time, so I just wanted to caution you, it's very likely we're not going to have time for questions at the end of this one, but we do have contact information provided as part of our materials, and if you want to reach out after, you can always feel free to do so. Now I'll briefly introduce our panelists in the order that they're going to be speaking today. First, we have Walter Calvert, a partner in our Baltimore office, works with the Tax and Wealth Planning Group and has a focus on state and local taxation issues. Many of you may be familiar with Walter, as he's worked with many of our nonprofit clients over the years. And a colleague of his also in the Tax and Wealth Planning Group that also focuses on state and local taxation issues is Miriam El-Khattabi. And Miriam is actually out of the Chicago office of Venable, and also has as I say, a focus on state and local tax issues. Then we have Jennifer Brzezinski, and Jennifer will be speaking on the labor and employment aspects of this issue as part of our program. Jennifer is a partner in our Tyson's office in Virginia. Many of you also may be familiar with Jennifer. She works with a lot of our nonprofit clients on employment matters as they come up. And her colleague, Haley Degnan, is also from the Tyson's Virginia office, also from the Labor and Employment Group, and also does work a lot with the nonprofit community. So as you can see with our panel, we're actually keeping with the spirit of today's topic being multi-state representation. We've got folks from Maryland, Virginia, and Illinois. So anyway, I know it's going to be a great program. I'll stop talking and let the experts go. I'll turn it over to Walter to get started. Thanks, everyone.
Thank you, George. So we're going to start off and try to keep at this first half hour of our time on the tax topics, and then change right over to the employment law side at the halfway mark. As George said, we probably have more than enough material to cover the whole hour, so I'm going to jump right into the fascinating but often complex, confusing, and inconsistent world of multi-state taxation when you have remote workers. Haley, why don't you move on to slide 5? It's hard not to get into this topic without noting the pandemic aspect of this, in that the rules we work with on multi-state taxation virtually always go back a long ways. If you've been there a long time, really haven't changed. The heightened attention to this whole area got triggered by the pandemic when we had an immense volume of workers working remotely, including volumes in state and local government, including workers in the state tax departments were working remotely. So if taxing authorities weren't focused on this before, the pandemic brought the awareness to them as well as to all of us in the private sector. The pandemic had state taxing authorities in many instances providing some relief, some safe harbors, but they were virtually always phrased in terms of as long as an emergency order from the state governor was in effect or something like that, all of which to say that virtually all of those relief from the pandemic period have gone away, and we're now left back where we started from with rules that go back a long ways and are highly varied among the states. The one big theme to take away from all of this with state taxes, other than one very focused area, state unemployment insurance premiums, the state tax rules vary immensely with a lot of inconsistency. The taxes we're talking about, and if we can go on to slide 6, include, there we go. Actually, the one that's on slide 7, I'm going to note is probably the most significant area, which is the payroll taxes. For a given employee, what state or states, multiple states, do you need to be doing withholding for them on? And also, sometimes the same, most often the same, but sometimes can have a different answer, unemployment insurance premiums. So that's probably for everybody the single most significant topic is just a remote worker. where is your payroll tax compliance going to be triggered? Back on the prior slide is the general themes that run across all businesses is income tax or nonprofits. This tends not to be a topic that really jumps to the top of your scheme because you're typically thinking of yourselves as, well, we're not subject to tax. And that is often the end answer in state taxation. But if you are actively having an employee in the state who's showing up on the payroll side of things, the state may well ask, well, where's your tax return? And if your answer is, well, we're a nonprofit, the next comeback be, well, did you file for exemption in our state? And so many states are going to have a process just like the IRS that you've got to go through to qualify not to be having to file register regularly with the state on the income tax side. Another piece of the puzzle is doing business. Virtually every state, all states have a process where if you're a business entity and you're, quote, doing business in the state, you're expected to register typically with the Secretary of State or some other state agency to get on the rolls as doing business in the state. And the presence of an employee can trigger that. It becomes a business decision whether actually just the mere presence of an employee causes you to actually go through that. Because if you do, it often then triggers the taxing authorities. Again, similarly ask, well, why aren't you filing tax returns in our state? Sliding back to slide 7, we've also got sales tax, which the general theme for nonprofits is typically don't have to pay tax when you buy stuff, but you virtually always do have an obligation to collect and remit tax if you're selling things. So there may be some instances where you actually are in a traditional selling tangible assets and are used to this. The area this has gotten heightened attention is a number of states have moved into taxing digital goods, which means if any part of the services you're providing to members or to the general public involve receiving compensation for providing what might otherwise be a book, a video, whatever, that's now being delivered in digital form, there are a number of states that will tax their sales tax on that and expect you, if you have enough connection with the state, including an employee in the state, to be collecting taxes in that state. Lastly, on the list of taxes to be aware of, last and least, because it's the lowest priority in all of these, is there are a number of jurisdictions at the local level, this will be county and city, will have a business, occupation, professional services tax that, again, if they're aware of you having personnel in their jurisdiction, I guess, why aren't you registered for and perhaps paying our local license tax? It's a core element of us funding our local government. So that's kind of a quick overview of the taxes we're talking about. Let me let Miriam come over with sort of the perspectives of the different participants in these taxes.
Thanks, Walter. So moving on to the next slide. It is important to consider the different tax compliance perspectives. For example, for an employer, it's important for an employer to determine where it has nexus, as this may result in adding additional states to its payroll tax compliance. This in turn would increase its tax compliance burdens, which means filing more forms or more tax returns with more states. For an employee would want to minimize its state taxation. For example, an employee may want to be taxed based on where they are working rather than where they live due to that state's lower tax rate. An employee would also want to minimize its state tax filing requirements. On the other hand, a state tax authority would want to maximize its state income tax collections. The state tax authority would also want to ensure consistent filing by all taxpayers having nexus with the states, and also ensure contributions to the unemployment compensation fund and ensure that that sales tax collection occurs. Moving on to the next slide, we're going to cover the basics of state income tax taxation. And as a starting point, there are 2 bases for a state to impose tax on an individual. First, a resident of a state is taxed on income from all sources. Second, an employee can also be taxed by a second state on compensation from working in that state. So as you can see in this scenario, an employee who lives in one state and works in another may face the issue of double taxation. And an employee can avoid this double tax by taking a credit on their resident state return. DC does have a special rule in that it does not tax non-residents who work in DC. The strictest non-resident filing obligations are found in Arkansas, Delaware, Kansas, Michigan, and Nebraska, where non-residents are required to file a return if they earn any income in the state. Other states like Colorado, Maryland, New Mexico, North Dakota, and Rhode Island require non-residents to file if they earn any income in the state and earn enough total income to be required to file a federal return. Indiana and Montana's exemptions are the broadest, as they allow non-residents to work within the state 30 days before filing obligations are triggered. Maine is unique in specifying that non-resident filing is only required after an individual has earned more than $3,000 in the state and has worked in the state for more than 12 days. It's also important to understand the employer payroll tax withholding. The general rule for employer payroll tax withholding is that it's based on the location of the employer's office. Now, there are reciprocity agreements between states which can alter this general rule. And under reciprocity agreements, withholding would be based on the employee's state of residence rather than the employer's office. And this would prevent the employee from having to file with two states. And it's important to note that DC, Maryland, and Virginia have such a rule. And turning it back to Walter to cover the convenience of employer rule.
So this is one of the most unpleasant topics for those who have to deal with it, but it's a very narrow world where it comes up, and there are only 6 or 7 jurisdictions that have this rule. The reason it gets so much focus is that New York is one of them, so that for all employers who have a significant office in New York, it potentially gets triggered. And if I back up to where Miriam was and I take the simple, traditional, conventional mode where employer is based in state number 1 and employee works in state number 1, but resides in state number 2, employer is generally going to do the withholding based on their state number 1, where the employee is actually working. And the employee is going to have to file their tax return in state number 2 as a resident, will pay all their tax to state number 2, but get a credit for the tax that's already been withheld for state number 1. That's sort of the traditional mode. Reciprocity rules often override that. And then you move along the slope and you say, well, what if that same employee is actually working most of the time from home, 90% of the time from home? Well, the usual correct answer would be the employer should be withholding probably for both states, because the work is actually being performed in 2 states for the employer. And if the employer knows that, they should be largely doing sort of a day count or some other count methodology to split the compensation between the places worked. And that got to be too commonplace a practice among employees and employers in the New York area, with employees working remotely in New Jersey, Connecticut, Pennsylvania, that New York was losing too much revenue, and years back said, we're going to override the traditional rules. And if, as a general theme, the employee is based out of an office in New York, we're going to treat them as working all the time in New York, irrespective of whether they actually may work someplace else, unless that remote work is essentially dictated by the employer. The employer is in fact requiring them to work remotely. And the requirement to work remotely is going to be one that's very hard to meet. It's going to be the case of an engineering company in New York, where an engineer gets assigned to work on a project that's happening in California and actually has to go and work on site to actually be performing its work on behalf of the employer as required by the employer in California. It's not going to be adequate that the employer says, yeah, we really are enthused about having you work from your home in New Jersey. That's not enough. New York's got a set of standards or guidelines that are pretty hard to meet for just your typical situation where the employer has acquiesced to the employee working remotely. And those guidelines don't really differentiate by how close the employee is in terms of their residence. The rules, I think, typically are viewed as just targeting the commuter type employee who lived in a adjoining jurisdiction, but their application, in fact, applies much more broadly. I don't want to belabor this much more because it really is a New York-centric rule. But if you have a key office in New York, you need to be aware of it in terms of any employees who then choose to work remotely. When we move on to the next slide, keep going. Yeah, so just a little bit on state unemployment insurance. This is one of the areas across all of sort of state taxation. It's not directly a tax topic, but it kind of ends up in the tax world as a payroll tax component, where there is a lot of uniformity across the states, and it's much more easy to take one state and assume it's largely going to apply. And the rule we've got here is the District of Columbia rule, but again, in most states, it's going to be the same theme. And this rule really works very well, and unlike what we just talked about, where you've got multiple states potentially taxing the same income and then having to sort that out after the fact to try to bring equality among not more than 100% of the income getting taxed. These rules target getting to a situation where just one state is going to be the state to which unemployment insurance premiums get paid. And the theme is sort of two-tiered with two rules. One is a localization rule, which is all the work performed in one state, or is all the work performed in one state and just some temporary or transient work is performed someplace else? So using DC as an example, if an employee is assigned to an office in DC and works, 1 day a month or a couple days a month out of their home in Northern Virginia, Rule 1 is going to kick in and say that work is localized in DC. Virtually all the work's performed in DC, and just a transient or incidental amount, temporary, occasional, happens otherwise. So DC is the employer, is the jurisdiction to which you pay. If you're not that degree of localized and you've got multiple states you're working in, it then slides to the second hierarchy of rules. There's a base of operations rule, which tends not to apply to most of our type. That's more of, you've got a plumber whose headquarters is in Maryland, and each day they go out and they may drive to Virginia and DC, but their place from which they depart each day is a given state. That's the base sort of rule. The one that's more generally going to apply is, if not base of operations, and the place from which direction or control is the one that's more typically going to be the secondary tier rule. So that if you got a remote worker, but who is in fact directed or controlled from DC, DC is generally going to be the place that has the right to collect unemployment insurance premiums from you. Again, unless the first rule is already kicked in and that worker is really spending 90% of their time working in Virginia, so that the predominant place of employment is Virginia, just based on Rule 1. But the essence of those rules are, they really focus in on only one answer at any given point in time as to what state unemployment insurance premiums get paid to. There are a couple examples on the next page that we're not going to spend time on. Those you can read through that help try to just clarify how different fact patterns would apply under the state unemployment insurance rules. Probably on the page 15, and the great topic of policy.
Yeah. So I guess a good question as an employer to ask yourself is, do you have a policy in place for personnel who want to work remotely? And if you do have such a policy in place, or you want to have one in place, does it cover first prior approval procedures for authorizing remote work? Employee roles for which remote work may be allowed? Are there performance standards for allowing remote work? How does remote work impact the quality of service that will be provided to members, clients, or other parties served? Are there adequate facilities, equipment, internet access, other needs at the remote work site? Are there any places that employees will not be allowed to work from? For example, a coffee shop. If you're working on client-sensitive data, you might say that's not allowed, or you need a privacy screen, for example. Are there any obligations of employees to give notice of changes to their work location? And this is important, as this could trigger state tax obligations. Does it cover short-term remote work? For example, if you spend 1 week at your vacation home, that might not be a big deal, but a 3-month staycation in a remote state could trigger state tax obligations. Also, does your policy cover applicable state tax withholding that will apply? And then also, does it provide notice to the employee of such tax? These are all important items to consider. They're not all inclusive. There are other items, but we're listing, and they're not listed in order of importance, but just for you to consider. And then we can move on to the next slide.
Yeah, so this is just kind of a practical heads up that you can often would find head off challenges down the road on state withholding rules if you make sure that, assuming you're hiring a third-party provider like ADP to do your payroll compliance, that you're focused when you enter any new employee, a new hire, or updating each year, your employee inputs, just how they use those inputs to decide how withholding works. And most of the time this goes through without really much thought, but there are exceptions we've encountered where if you don't kind of get it right with an understanding of how they're treating the inputs, particularly when you get to things like the New York convenience of the employer rule, you can get withholding being triggered in a way that you don't really intend it to happen. And just one note we've also encountered is one of the inputs in these forms is often now keeping track for Equal Employment Opportunity Commission reporting for your own benefit. They will have you assign an employee to a particular office for that count, and the general theme that trying to make sure that input for that purpose is consistent with the way you're otherwise treating the employee for withholding purposes, to the extent there's an office you're trying to assign them to, and that those two are consistent and won't later result in the question of why they're different. Onto our slide 17. So the topic of, as you get down the road and encounter these topics, is there any given place, good place to kind of go to try to get easy answers? Well, overall, not so much, but here's at least one that tries to provide, for a lot of the states, some degree of guidance on the withholding nexus filing rules, which is one of the big tax service providers, Wolters Kluwer's, does have a website with the link here that's going to have pretty decent guidance in a big picture way across the states. Then, a lot of this theme, as I mentioned to start, is states are not consistent on this. For many years, there's been movement at the federal level to try to dictate greater consistency on remote workers and consistency among withholding rules, if nothing else, setting some minimums as to a floor of how many days an employee must work before a state's going to subject them to tax, or some de minimis dollar amount across the states before their incomes can be taxable. This legislation's been around forever, it seems now, and it never goes anywhere. Congress has not been able to get a sort of bipartisan bill that can be agreed on. This bill from 2020 during the pandemic has been sort of the main mover in the area that someday might go somewhere, although I'm not real happy or thinking it's going to happen anytime soon. But that's sort of our quick overview of state and local multi-state rules. I note for any of you signing up for CLE, our code that you'll need to be inputting is remote 24. The word remote followed by the numerals 24. Jen and Hala will shift it over your way for the employment focus.
Great. Thanks so much, Walter. Hi, everyone. Good afternoon. So, as we've been saying, the experience of remote work during the pandemic, really demonstrated for many nonprofits that the needs of their business can be achieved through either a fully remote work or a hybrid work model. So as a result, many nonprofits are now hiring employees in states in which they've never had employees before. And because each state's employment laws differ, there are really some unique employment issues that a nonprofit faces when they're trying to manage this multi-state workforce. Next slide, please. So what we've done is broken down these unique employment issues into three main areas. First, we're going to talk a little bit about issues at the beginning of the employment relationship, then during the employment relationship, and at the end of the employment relationship. What we're going to do is discuss in each of these three areas the particular issues that arise, as well as the common variations in employee rights and entitlements amongst these various state laws. And then hopefully we're going to provide you with some assistance and make some suggestions with regard to strategies to kind of maximize technical compliance when you're trying to comply with all of these various state and local employment laws in multiple jurisdictions. Next slide, please. So now we're going to go ahead and begin with the issues at the beginning of an employment relationship. And so in our practice, we see nonprofits sometimes struggle with whether to classify a worker as an employee or as an independent contractor. So to determine how a worker should be classified, a nonprofit should start with applying the Federal Department of Labor's test for independent contractors. However, it's really important to remember that a state may apply a independent contractor test that is different or more stringent than the Federal Department of Labor's. So it's actually possible that a worker could be classified as an independent contractor under the Department of Labor's test, but not under the applicable state's test. So what you'll want to do when you're making this worker classification, you'll want to apply both the federal test as well as the applicable state test when you're making the determination. So under federal law and many state law, there is a presumption that the worker is an employee. So meaning unless the worker can be shown to be an independent contractor under the applicable test, the worker should be classified as an employee. So you're already starting from a pretty high bar here. There are various multi-factor independent contractor tests that are used by states. And it's really important to get workers classified properly because employers with misclassified workers may be violating wage and hour laws or tax laws, and liability for misclassification can result in unpaid overtime to your organization, claims for failure to provide state mandated benefits, as well as civil penalties. In addition, it's also important to note that some states now have given the worker a right to bring a private cause of action when it comes to misclassification of independent contractors. So what I mean by that is a worker can immediately file a lawsuit against the employer in court rather than being forced to file a complaint with the state's Department of Labor. So Virginia is an example of a state that gives workers a private cause of action to bring a claim for misclassification of independent contractor. So what we've done here is we have a chart that shows the states which use which independent contractor test. We hope this is going to be a helpful reference, but just remember this is a reference and you'll want to just make sure and follow up and make sure you're applying the laws properly. So what I'm going to do is go through each of these tests, and I'm going to start with the Department of Labor's economic reality test. So the U.S. Department of Labor issued a new rule that provides guidance on how to analyze worker classification under the Federal Fair Labor Standards Act. Now, the rule became effective of March 11th of this year. I say it's a new rule, but it really isn't. It's actually just a reversion back to the rule that was issued by the Department of Labor during the Obama administration. The rule changed under the Trump administration, and so now we're going back. But when we're talking about this economic reality test, it's important to remember the key focus of the test is whether the worker is economically dependent on the alleged employer, or as the Department of Labor puts it, whether the worker, as a matter of, quote, economic reality, is dependent on the employer, or is the worker actually in business for himself, herself, or themselves? When we're applying this economic reality test, you'll need to consider 6 factors here, and no one factor is dispositive of the classification. So we've got the factors listed up here. Again, hopefully it'll be a useful reference for you. I'll briefly go over the factors. They include the opportunity for profit or loss, depending on the worker's managerial skill. And that essentially means whether the worker can accept or reject work offered by the nonprofit in order to increase their profit. Also, this test looks at the investments made by the worker and the employer. So really what that means is, does the worker pay for their own equipment? Do they pay for their own regular expenses? Do they provide their insurance? Or is it really the nonprofit that's providing the worker with those things? If it's a nonprofit providing those things, it looks more like an employee relationship and shows that economic dependence. Next is the degree of permanence of the work relationship. And what that means is the relationship indefinite, right? Does it look like an at-will employment relationship, or has the worker been hired for a fixed term, of a few months, or for a specific project? You'll also need to consider the nature and degree of control over the work. Does the worker or the nonprofit control how, when, or where the work is performed? Also, this is a big one that you'll want to make sure that you're looking at, is the extent to which the work performed is an integral part of the worker's business. The more integral the part of the employer's business, the more likely the individual is going to be classified as an employee. Outside the employer's regular business, more likely to be an independent contractor. And then finally, the skill and initiative required to perform the services. Does the worker have a specialized skill, or are they just really doing something that other employees are doing? Next slide, please. Now I'm going to talk a little bit about the common law independent contractor test that is used by some states. Again, this is a multi-factor test in which all factors should be considered. For the common law test, the key question here is who controls is the operative word, what work will be done and how it will be done. And when I go through this test, you're going to see that there are definitely similarities and overlaps between the economic reality test and this common law test. So the first category that you'll need to look at is the behavioral control, meaning does the nonprofit control or have the right to control the worker or how the work is performed? So when you're looking at this factor, you'd look at the types of instruction given by the hiring entity. Is there a lot of instruction here? Are they directing where to do their work? Are they directing what tools to use to do the work? And how much instruction is given. Is it a lot of instruction, or is it just high-level instruction? And then also whether the nonprofit is providing training to the worker in order for the worker to perform the services. Performing training looks more like an employee relationship. You'll also want to look at the financial control, which is are the business aspects of the worker's job controlled by the nonprofit? For this factor, you'll look at how much the investment the worker has made in their own business, whether the worker pays their own expenses, whether the worker can seek out other business opportunities. Can they go go work for somebody else? And whether the worker is paid on a flat fee basis or a project basis, or are they paid, weekly or on an hourly basis? And then finally, the common law test examines the relationship of the parties. So here we're looking at what is the duration and nature of the relationship between the parties. For this factor, you're going to examine the written agreement and what it says. Does the worker receive employee benefits like paid time off, insurance, things like that? And is the relationship indefinite or fixed? Again, does it look like an at-will employment relationship, or is it really a short duration or for a particular project? And then finally, are the services performed a key activity of the business? So that's the common law control test. And now we're going to discuss the most stringent of the independent contractor test. It's the ABC test. Next slide, please. So the ABC test is different than the other tests. This is important because in order to be able to classify a worker as an independent contractor under the ABC test, each factor must be met. It's not a weighing test. So under the ABC test, a worker, again, is presumed to be an employee. So we have to meet all these three factors in order for the worker to be classified as an independent contractor. Presumed to be an employee unless the worker is free from control and direction of the potential employer in relationship to the performance of the work under contract and in fact. So basically, it means not only does the contract have to say that this is an independent contractor relationship, but when you look at what the worker is actually doing for the potential employer, are they actually an independent contractor? Are they free from that control and direction when they're actually performing the services? The worker also needs to perform work that is outside the usual course of the potential employer's business. And this is the one that I would say most businesses get caught up on when they're trying to classify somebody as an independent contractor. Are you hiring somebody to, design your website, or are you hiring them to, manage one of your grants, right? The former, designing your website, that's likely to be outside your usual course of business. Managing a grant may be likely to be part of your usual course of business. And then finally, the worker is customarily engaged in an independently established trade, occupation, or business. And again, what they're looking for is that independence and that there's a separate business that's been established. The worker is working for multiple clients and things like that. And obviously, this is a really stringent test for nonprofits to meet. And so under the test, if it's applicable, a lot of times it's going to result in workers being more likely to be classified as an employee rather than the independent contractor. And it is important to note that, the Department of Labor, the U.S. Department of Labor, actually specifically declined to adopt this test. They didn't want to apply this level of stringentness to the situation, right? And so they used that economic reality weighing test. Next slide, please. Okay, so again, trying to provide assistance to you in trying to see if you can meet both the federal and state tests that are applicable when you're doing worker classifications. What we have here is we've listed factors that are usually indicative of an employer-employee relationship, and those that are indicative of independent contractor relationship under the majority of the test. And again, be careful of the ABC test. But signs of an employer-employee relationship are the worker performs work traditionally performed by employees and exclusively for one business. It looks like an indefinite at-will employment relationship. The worker is paid on a salary basis. The employer is supplying the tools, giving them the laptop, giving them the email account, giving them business cards and equipment to perform the services. And also the employer directs when and how the work is to be performed, meaning you need to be in the office 3 days a week in order to perform these services. And we need you to do it in this, very specific manner. Again, those are factors for the employer-employee relationship. And then on the other side, here are signs of an independent contractor relationship. So the worker performs work that is part of an independent business for multiple clients. Again, multiple clients is a really helpful factor here. It's also, the workers also engage for a defined period of time or on a project basis, right? You're hiring them to design your website, or you're engaging them for a defined period of like 3 months or 6 months. The worker is paid on a flat fee basis, project basis. The worker is providing their own tools and equipment, and then they're also setting their own schedule, and they can do their job whenever they see fit, perform the service whenever they see fit. And then finally, the worker is the one who is determining how the work is to be performed. How is the work going to be executed? Again, there can be some level of supervision or instruction, I should say, that's given to the independent contractor. It just can't be a great deal. So now I'm going to turn it over to Haley to talk about employee classifications.
Thanks, Jennifer. So employee classification is another issue that is pivotal for employers with employees in multiple jurisdictions. And by employee classification, we mean whether an employee position is classified as exempt or non-exempt under applicable wage and hour laws. Now, most employers are aware of the test for classification under the federal Fair Labor Standards Act and closely track that. But what sometimes gets overlooked is that multiple states and localities have their own counterparts to the federal FLSA, and that in some cases there are variations as to when an employee will qualify for an exemption under those state or local laws. And there are also some variations in the requirements that apply if the employee is non-exempt and subject to the minimum wage or overtime requirements under those laws. So as we said, every employee position is classified as either non-exempt or exempt under applicable wage and hour laws. Non-exempt employees are entitled to a minimum wage and overtime pay. Exempt employees are ineligible for the overtime pay and minimum wage. Under federal law, the Federal Fair Labor Standards Act, the overtime pay requirement is that if an employee works over 40 hours in a work week, they're entitled to 1 1/2 times their regular rate of pay for each hour over those 40 hours. Now, not all state laws have wage and hour, not all states have wage and hour laws, and even those that do, don't all have overtime pay requirements. But as you'll see on the chart on the slide here, some have incorporated additional requirements beyond the federal law. So the majority of states track the Federal Fair Labor Standards Act and require overtime pay if an employee works over 40 hours in a work week, and them to receive 1 1/2 times the regular rate of pay. But there are a handful of states that are going to go beyond the federal law. And so just by way of example here, California law requires an employee to receive overtime if they work over that 40 hours. In a work week, they also have to receive 1 1/2 times their regular rate of pay if they work over 8 hours in a day, or if they work 8 hours on a 7th consecutive workday. And then California actually recognizes double overtime, where an employee has to receive double their regular rate of pay if they're working above 8 hours on that 7th consecutive workday, or if they work over 12 hours in a given workday. Colorado is another state that has additional overtime requirements. Under Colorado law, employees get overtime if they work over 40 hours per work week, that same 1 1/2 times the regular rate of pay as federal law. They will also get overtime pay if they work over 12 hours in a given day or over 12 consecutive hours. Oregon is another state that has additional overtime requirements, but it handles that industry specific. So that's going to be an industry specific requirement. And then Rhode Island, under some circumstances, employees may be entitled to overtime for working on a Sunday or working on holidays. So generally, when we're looking to see if an employee qualifies for an exemption, there's a 2-part test that must be satisfied. And this is generally true under federal law as well as state law, though as I'll get into shortly, there are variations. The first part of that 2-part test is a salary basis test. So generally speaking, and for most exemptions, an employee must be paid on a salary basis, and that salary basis must equate to above a certain threshold. And the thresholds under the Federal Fair Labor Standards Act were recently increased in July of this year to equate to $43,888 per year. Those thresholds are set to increase again in January 2025. Those increases have been challenged in court, but as of yet, they've been upheld and found to be enforceable. The second part of our test is a duties test. So if we have an employee position that meets the salary threshold, we look at the primary duties that that position is performing. And when I say primary duty, we're looking at kind of the major functions, relatively what they're spending the bulk of their time doing, and the relative importance of those duties. So by way of example, one common exemption under the Federal Fair Labor Standards Act is the administrative employee exemption. So you'd look to see if an employee satisfies that salary test. And then for the administrative employee exemption, we're looking to see if that employee position performs duties that are customary to the management of the business, and whether it involves the exercise of independent discretion and judgment over matters of significance. Now, where these state law variations come into play, a couple of states that you'll see on the slide there have a higher salary threshold for an employee to qualify for an exemption. So in order to satisfy that first test, there's a higher amount that that employee must receive on a salary basis. California having the highest of all states, though California also has some industry-specific variations to that as well. Additionally, not all exemptions that are recognized under the Federal Fair Labor Standards Act are recognized under applicable state wage and hour laws. So I mentioned the administrative employee exemption. Under federal law, there's also a highly compensated employee exemption, a computer employee exemption, an executive exemption, just to name a few. Not every state recognizes all of those exemptions. By way of example, California, Colorado, and Illinois do not recognize the highly compensated employee exemption, and DC and Connecticut do not recognize the computer employee exemption. There are additional states beyond just those. There also are slight variations in those duties tests. So what the primary duties of the employee positions are to qualify for an exemption may vary slightly from state to state. So now that we've kind of determined the classification of the employee or the engagement of the employee or independent contractor, there are also some variations that might come into play in our hiring practices. So for job postings in particular, states may impose certain substantive requirements or information that must be included in a job posting. And one area where we've seen this increase kind of exponentially over the last few years is with pay transparency laws. Pay transparency laws generally require employers to disclose information about employee compensation, either in the job posting itself or sometime early on during the hiring process. Approximately 12 states and DC have passed these pay transparency laws. Those include California, Colorado, Connecticut, Hawaii, Illinois, Maryland, Minnesota, Nevada, New York, Rhode Island, Vermont, and Washington. And fortunately, for compliance purposes, there is no one-size-fits-all for these pay transparency laws. We're seeing quite significant variations from state to states. So some states have different employer coverage requirements. So for instance, in Hawaii, an employer is only covered by the pay transparency law if they have over 50 employees. In California, it's an employer with over 15 employees. Colorado, which is probably the most robust of all state pay transparency laws, actually takes the position that all employers are subject to its pay transparency law, but there is an exemption for employers that are not physically located in Colorado and who have less than 15 remote employees in Colorado. Beyond the different coverage requirements, there are different timing of disclosure requirements, and also the substance of the disclosure may vary from state to state. So most states require the disclosure to occur in the actual job posting, but some states have taken a more limited position. For instance, under Maryland law, the disclosure only needs to occur if an applicant for employment requests the salary range. And then some states have taken the position that this not only applies to job postings that are made externally, but also to promotional opportunities and internal job postings as well. It's also worth noting that some localities in states that have pay transparency laws have passed their own pay transparency laws, and then some localities in states without pay transparency laws have passed their own pay transparency laws. So for instance, Ohio is not a state with a pay transparency law, but Toledo, Ohio is a locality with a pay transparency law. So moving on now to employment and other forms of agreements. Generally speaking, all states, aside from Montana, permit at-will employment, meaning that you can fashion the employment relationship as at-will Either the employer or employee may terminate the relationship at any time with or without notice for any reason. Montana is the one exception, and after a probationary period, Montana employees can only be terminated for good cause. In terms of the actual offer letter or employment agreements, many states do not impose specific substantive requirements, so they're not restricting what exactly needs to go in those offer letters, but there may be other notice requirements that apply upon hire that an employer could incorporate in the offer letter. So for instance, some state laws require employers to provide notice upon hire of the timing, frequency, and method of payment. Illinois is one of those. And you could incorporate that information into an offer letter to satisfy that notice requirement. Another one that some states have is that employer contact information must be disclosed upon hire, adding some kind of header to an offer letter with the main business address and phone number could satisfy that requirement in various states. New York is one of the states that has that. Paid leave benefits. A few states will require the employer upon hire to provide a description, particularly if the state has a paid sick leave law, of the type of paid leave available. And that can be satisfied either by including additional information in an offer letter or supplying a separate notice. If an employer is going to try to incorporate these additional notice requirements in an offer letter, an employee signature may be either required or beneficial to add, because some notice requirements require the employee to sign off. Other types of employment agreements where we're going to see variations at the state level include restrictive covenants agreements. We've seen generally a trend for states to become more and more restrictive. And we actually recently saw the Federal Trade Commission attempt to ban non-competes at the federal level. That rule, which was passed recently, was actually found to be unenforceable. So at least at the federal level, there aren't the same types of restrictions that we're seeing at the state level. All states have a reasonableness test for restrictive covenants, particularly non-competes and customer non-solicits. And we're looking at the reasonableness test. It's whether the restriction is no greater than necessary to protect the employer's legitimate interests. So some factors that are considered for reasonableness include the geographic scope, the duration of the restriction, and the types of services involved. Many states have gone beyond that and have passed specific statutes which limit the use of non-competes or customer non-solicits under certain circumstances. So there are a handful of states with outright prohibitions, California being the main one, generally prohibits the use of non-compete agreements. There are many states that have now taken the position that non-compete agreements are void against certain employees. So they actually have a salary threshold for which employees may execute a non-compete agreement. Some of those states have also incorporated procedural requirements that apply. So employees need to be given the agreement with a certain amount of time to review it in order for it to be enforceable. And then some states have deviated from maybe going that far and have just incorporated presumptions, which apply to the reasonableness test that they're going to use. So for example, Illinois' law, the Freedom to Work Act, has specific salary thresholds and requires employees to be given 14 days to review the agreement or receive the agreement 14 days prior to their employment in order for a non-compete to be enforceable. Florida doesn't have that kind of strict restrictions, but it does incorporate presumptive durations for a non-compete. So under Florida law, a 6-month non-compete is presumed to be reasonable. A 2-year or longer non-compete is presumed to be unreasonable. And with that, I will turn it back over to Jennifer.
Okay, great. Thanks, Haley. Okay, next slide, please. So one area that we're seeing a lot of increased inconsistencies among the states is anti-discrimination and anti-harassment policies and training. Here, it's just important to note that many states have additional protected categories beyond what's protected under federal law. So at a minimum, you should definitely have in your policy state that any other category protected under federal, state, or local laws. But you should also be mindful that Some other states impose content requirements on anti-discrimination harassment policies, such as New York. New York also requires a particular complaint form. Some states require the enforcing administrative agency and contact information to be included in the policy. And then there are some states that require employers to provide anti-discrimination and harassment training. There are certain restrictions sometimes with regard to that training. They may dictate the frequency and the duration of training, and as well as impose content requirements. There are on various websites, on state websites, model policies and training samples that can be used as a resource. Next slide, please. So this is the area that we see probably most clients struggle with, is trying to comply with the various state and localities' paid time off policies. So we have here, a couple of charts. So with regard to paid vacation, though it's generally not required under law, some states have requirements regarding paid leave. For example, use it or lose it policies and caps on carryover are not permitted in all states. Some states require payout of accrued unused vacation upon separation. To try to avoid complying with all of these various issues, an alternative would be to implement an unlimited paid vacation policy, which nothing is paid out. Although, there are sometimes potential negative consequences to implementing paid vacation policies. You'll also want to be mindful of, states' paid sick leave laws. There are definitely different paid sick leave laws with regard to whether the paid sick leave is accrued or whether it can be front loaded at the beginning of the year. There's typically different rules that apply depending on which method is chosen. Definitely watch the caps on carryover for paid sick leave. Some states actually prohibit caps on carryover. So the unused accrued paid sick leave will carry over from year to year, but those states oftentimes will permit usage caps, meaning you can limit the amount of sick leave an employee takes in a year. Again, in drafting your policies, you want to make sure they cover all uses recognized under local and state laws. We have a chart here that you can look at that have the common uses. And then finally, with regard to, combined PTO policies, you'll want to make sure it complies with applicable state and local laws governing both paid vacation as well as paid sick leave. Do watch out for employee eligibility here. Many of PTO policies, combined PTO policies that we see are limited to full-time employees, but many paid sick leave laws provide that all employees, including part-time and temporary employees, have to be provided with sick leave. And as an alternative, you can certainly use unlimited PTO to try to comply. We have a couple of the chart here showing states that prohibit use it or lose it. The asterisk from Nebraska just means that there's no outright prohibition, but there are, but some have read it as prohibiting. So there are some cases that prohibit have been read, as prohibiting use it or lose it policies in Nebraska. The asterisk for the chart showing paid vacation leave upon separation indicate those states have some exceptions to when vacation leave must be paid out. Next slide, please. Another area that we see, and I know we're bumping up on time here, so I'm going to turn over to Haley after this slide. Just be mindful that even if you don't have 50 or more employees and aren't covered by the Federal Family and Medical Leave Act, some states have their own paid or unpaid family and medical leave laws. Some of these laws cover smaller employers, right, less than 49, sometimes 15 to 49 employees. Some of the laws are used to extend leave into additional circumstances than the Family Medical Leave Act requires. Some don't require providing separate banks of leave, but extend the leave to certain groups. Approximately 13 states and DC have mandatory paid state paid family and medical leave systems. These systems generally are set up like unemployment insurance benefits, where the employer pays a payroll tax that goes into a state fund. The employee applies for the benefit through the state, and if granted, the employee receives the wage replacement benefit from the state, and then the employer is required to provide the corresponding leave. And I'm going to turn it over to Haley, who's going to talk a little bit about other types of leave and wrap up here.
Yeah, we're at time, so I'll run through this pretty quickly. Various states have other forms of leave that employers are required to provide. We've included some common examples on the slide. A lot of these forms of leave are unpaid. And when you're trying to manage all these various different forms of leave, always check the definition of employer or the coverage of employer. You might find that, this state requires this form of leave, but it only applies to employers with 50 or more employees. And so I do not have to provide this type of leave. And then one approach to handling all these various forms of leave is to find the type of leave, the state that has the most generous requirement and comply with that state so that you're complying with all other states and your base handbook is compliant. Otherwise, you can draft a more restrictive base handbook policy and then supplement as needed for specific states. There are other policies beyond leave policies that may require modification for compliance with state law. Common examples are reasonable accommodation policies, particularly lactation accommodation policies, meal and rest break policies. So some states require specific amounts of meal and rest breaks, wage payment policies. Some states require employees to be paid at a certain frequency, so at least bi-monthly or semi-monthly, so monthly payments may not be compliant. Some states prohibit requiring employees to use direct deposit. Employees have to sign off on direct deposit, and then providing employees with access to personnel records. And even those states, even those laws vary from state to state. There may be a timing requirement in which the employer needs to comply. There are only going to be certain types of records under the various state laws that need to be provided. Finally, looking at the end of the employment relationship, there are some state-specific considerations. If it's a reduction in force, there may be a mini WARN Act that applies if multiple employees obviously are being terminated at once. The timing of final payments to a separating employee is going to vary from state to state. In some cases, it's immediately. Most cases, it's by the next regular payday. There may be certain requirements for separation agreements, and there may be notices that need to be provided to an employee upon separation. So with that, we can wrap it up, and I'll repeat the CLE code is remote 24. That's remote 24. Thank you so much, everyone.